Hello, everybody. Harry here, and I'm with the existential version of my good friend Andrew Weissmann to talk about the big story of the week, the Mark Pomerantz book about the investigation that Alvin Bragg scuttled about a year ago. So much to talk about, and if I can pat ourselves on the back for starters, I think in these settings, Andrew, it really helps to have people like you and me who have been at places where decisions were made in front offices and the like, and not simply line prosecutors. So I'm hoping we can shed some light on a pretty complicated and in some ways gnarly story. So first, thanks for being here.
It's always great to be here. I note that I think we're bi-coastal now because we have LA and New York covered. Nothing in the middle of the country yet, but okay. Ready?
Well, we're you've heard about them, they're, coastal elites. So I guess that's us. Um, Man, where to start? Let's just start here. It's one of the big ticket items. Bragg says, I haven't even read the book because, this is kind of a non sequitur, but because he thinks it could do damage to the prosecution. The book, presumably, not his reading of it. Let's zero in there. And Rachel Maddow was kind of pushing Mark Pomerantz on that point. So Pomerantz's defense is one, all the facts are out there, especially in Tish James's civil suit. And two, for the most part, stuff in there like the teeth gnashing about Cohen's value as a witness wouldn't be put in front of a jury. So what do you think? I'm not. This is not to fault him. I think you, more than as much as anyone, but I have the same view. It's okay to write a book as long as you stay within the rules. We don't know that he didn't, no grand jury stuff. But just as a practical matter, how unwelcome is this to Bragg's current efforts? How much can it kind of, muck things up for him?
So I think there's sort of two issues that are embedded in what you asked about. One is the nature of what Mark Pomerantz did in writing a book in these circumstances, and then the second is what's the harm.
Yeah,
So the
especially the second. Yeah.
So the first part, I just want to make sure people understand. This is a book that is being written by a former prosecutor after, by all accounts, leaking his resignation letter, disparaging somebody who is under investigation but not charged, CEG Jim Comey with Hillary Clinton, but now the shoe's on the other foot. It's with respect to Donald Trump. And did not submit the book for pre-publication review or any sort of review by the office. And, as I say with respect to that, I've said John Bolton submitted his book for pre-publication review. Of course, I submitted.
As did Andrew Weissmann.
Yeah, of course.
Right. Yeah.
You know what? That's one of these things it's not just that you've agreed to do it, it's the right thing to do. Because regardless of what you may think may not need to be redacted, you're not the end all and be all in making that judgment. And it's not just about classification and grand jury, but there's all sorts of issues about what might be privileged or what might harm an underlying investigation. Mark Pomerantz can't know what has happened once he left. So he can't really make an informed judgment by that. So if I were the DA or the general counsel of the DA, I would be royally upset because of that constellation of that happening, especially because it's an ongoing investigation. Now turning to your how could it be used?
Yeah, although just to add the exclamation point to that, Pomerantz might have not known at the time, but not just ongoing. but he has revived it in a way that Pomerantz, even without revealing things, kind of dumps all over, makes it seem like the so-called zombie case, we'll get more into this, is really minor league and dibby-dab next to the big righteous prosecution they were pursuing. But
So
yes, the
yeah,
harm.
it's a separate issue. The
Yeah.
harm issue is there's there's sort of different ways to look at it. There is no question that the book, if there are charges, will be used by the defense, because why not? I mean, I think we've all been defense lawyers. It's like, that's your job. If there's a 0.1% chance that this could help you, why not go for it? There's no downside for the defense. And if you look at the Trump Organization Weissenberg trial, there was a lot of pretrial litigation about these kinds of things. Obviously not a book, but about all sorts of pretrial publicity issues. The kinds of issues that could be raised: selective prosecution, change of venue, tainting of witnesses. Just a whole variety of things that will go into the mix. And this is where creative defense lawyers think of all sorts of arguments.
Right. And by the way, more than even tactical legal motions in limine, they've got a blueprint into what everybody thinks about Michael Cohen, who, as we sit here now, still looks like they're planning to use. That's just totally valuable stuff, whether you anchor a motion in limine, which for listeners is just a sort of pre-trial legal motion to exclude things, whatever. That's just a valuable vantage point to have had. And they may be able to smuggle it in one way or another, at least before the judge.
Yes, and it actually could become something at trial because there is information in there about what witnesses said at certain times. If there is a witness who has read it and been exposed to it, it could come up in
Yes.
cross-examination. In other words, defense lawyers are ingenious, as they need to be, and they will figure out ways to get that in, that a former prosecutor thought X, Y, and Z. But by the way, the current administration thought this was a weak case. I mean,
Right.
it's like,
Objection. Oh, please disregard that, jury. Ha, ha, ha. Right? Yeah.
it's like, I'm sorry, what do you want them to disregard? Could you?
Yeah, exactly. Yeah, could you don't let it know that there were people in the room who's Mr. Bragg, please approach the bench. Yeah, I'm sorry. So go ahead.
So what's so unusual here is the idea that this came out in the middle of an investigation. And even if you take the view that Mark thought at the initial steps that maybe the investigation was over, certainly by the time of the publication, he knew that's not true. There were many public reports, but also it doesn't answer why he leaked the resignation letter. I mean, that to me, for all of the reasons all of us were completely disparaging what Jim Comey did in both July and October. This is what the rule of law means. The rule of law means you don't say it's procedurally the wrong thing only because it was Hillary Clinton. If that's the wrong thing to do, it's because you don't disparage somebody who is under investigation but not charged. And I don't.
Yeah, let's take an apt comparison that came a couple weeks ago if people didn't see it. Nora Danahy. She was really upset with what her boss did, John Durham, and she did what used to count as the ultimate protest. She quietly resigned and never talked to anybody. So that's sure. Look, let's just cut to the chase here. There's a lot of score settling, and this would have been the biggest case of his career. He'd been brought in to do it. The Vance had given every indication he was gonna. Bragg pulls the plug. There's no doubt that the bruise of that, is channels into a book that is somewhat politic toward Bragg, but reading between the lines, some real zingers and really insulting to the office as a whole. Yeah.
Yeah, I think I wouldn't necessarily. I think the jury's out on whether he pulled the plug. I think I read this as Vance, I think, did not give a clear go ahead and indict, because it doesn't explain if that was what he actually said. why there wasn't an indictment. And I think what Vance did was
Yeah.
actually the correct thing, which was to say, I am supportive of going forward. If it were me, I would do it, but I am not making that decision because it is the next DA's decision.
We'll have to live with it. A provisional, okay, I think that's absolutely right. Yeah.
Pomerantz knew he wasn't getting the go-ahead from, because he would have, if he got the complete go-ahead, why not just go ahead and indict? And so he knew he had to go to Bragg for it. And then my view is it's really clear he jammed up Bragg. He deliberately keeps him out of being briefed on it before he is sworn in January. He's not invited to the so-called summit meeting with outsiders being briefed on the case. And he then tries to sort of ram this through with a sort of ultimatum of not just, I'm going to leave if you don't go forward now. Not like, I need a decision now that you're going forward, a decision that you are going to continue this or need more time, or you want a prosecution memo, is I'm quitting. And he says something in the book that I just found completely outrageous, where he says, wouldn't it be terrible if, obviously everyone's going to know if I leave, it's going to be known immediately, but wouldn't it be terrible if people learned that Cy Vance agreed with me? It won't be good for you. And then he leaks his resignation letter that says that. I mean, that is just not how you behave. I mean,
Absolutely. And by the way, there's already all this tension when he's there because he's brought in and there's resentment in the office. I do want to sound one counterpoint here. Maybe we can gin up a little bit of disagreement between us. Always fun, as we learned last week. There's I think as you might put it, the jury is out here. I thought there were credible accounts at the time, not simply from Pomerantz, that had Bragg himself at arm's length. Bragg himself having not a prosecution memo per se, but an important summary memo on his desk gathering dust. Bragg himself, who in the most important meeting he was at, coming late, leaving early, looking at his watch, etc. Bragg himself, who didn't truly engage Pomerantz and Dunn. And who did seem not, although after there was a lot of protest, he said, yeah, well, look, we're not completely closing it down yet. But Bragg, who did seem at the time to basically be putting it in mothballs. So there's a factual dispute as to how Bragg, everything you say is true about Pomerantz. The question is, was Bragg kind of arm's length and underwater and worried about being the new guy coming in and taking this on? I think there's genuine dispute about that.
Yeah, that may, this is one of the things where we don't know.
It's Rashomon all over this damn book, right?
And it could be
Mr. Existential. Yeah.
Well, it could be sort of a combination because all of that could be true. I mean, my big question,
yes,
you or Pomerantz, would be, I don't understand, why wasn't he invited to the summit meeting? If you're bringing in outsiders and you're briefing them on everything to get their views on what you think, and you know that the new DA is going to need to get up to speed and is going to need to opine, what is the valid, legitimate, good faith basis that you're not including him in that meeting? It is.
I can see that you're waiting to get that crystallized and then come up to him with an overall consensus, or an overall assessment. As U.S. attorney, I can imagine something like that would have happened. However, let's go cut to the summit meeting, where by all accounts there were real strong divisions of opinion among lawyers that Pomerantz respected. And the thing that is maybe most glaring to me about this current PR tour is it's a single soundbite, but it's the biggest soundbite, and everybody bit his now saying, if it were anyone other than Trump, there would have been an indictment in a flat second or whatever. That's just inconsistent with what seems to be a very strong view from many quarters that there was honest disagreement about it. He himself puts it at 70%. That's not a flat second. Nicole Wallace asked yesterday on it, wouldn't I have been indicted? And, I said, no, it's just not clear. You don't necessarily go around indicting on 70% cases. But that
Yeah.
I think that just can't be squared with this flat second idea.
I agree, and I think the two counterpoints I would make are uh, Mark Pomerantz was asked about sort of Alvin Bragg's comment that the plane wasn't ready for takeoff.
Yeah.
And Mark Pomerantz said, well, no, because the plane was taking off in another airfield, and pointed to the Letitia James case. But Mark Pomerantz is smarter than that. To say that
Yes.
there's a civil case where the critical evidence was there was some evidence, there wasn't strong evidence of direct knowledge of intent, but they can use the assertion of the Fifth Amendment, and those are sprinkled throughout the complaint. You can't say, well, this was clearly a case that's ready for takeoff, and point to a civil case. This is a criminal case. You have to prove beyond a reasonable doubt. So I think that's one data point. And the other is the statement that this would be true for anyone else, I think, is belied by something that Mark, to be fair, candidly admits he was a proponent of when he was there, which was that he thought you could charge Donald Trump for money laundering, and that the predicate, something you need to prove money laundering, is that there's an underlying crime, and the underlying crime was that Donald Trump was the victim of extortion by Stormy Daniels,
Of a blackmail.
and no prosecutor.
I mean, that's not his finest. That's like, that's a different universe, right? Yeah.
But just so everyone understands, no prosecutor is going to prosecute the victim of an extortion as a money launderer. And the problem is that if you're thinking that this is treating likes alike, and that this is not selective prosecution, and you are treating everyone the same, which is the goal here, you can't say, I came up with this wacky theory where a victim gets prosecuted and we're going to use it for Donald Trump, but we've never used it for anyone else, and say that your whole goal is to have the even-handed administration of the law. So if you're Alvin Bragg and you hear that that's one of the theories that the person's coming to you with, Mark Pomerantz, to his credit, says, I know I lost credibility over this. And that is, Harry, you and I would have the same reaction.
Yeah, no, I mean, that is so cockamamie. I think there's a factual question whether Bragg heard it, and that was one of the reasons. But the notion that it's not simply, because he's a smart guy, Pomerantz, it's not simply that it's out there. It's that being so out there bespeaks a kind of flailing on his part and the part of the team. If you're groping for this kind of theory, then you obviously don't have a dead bang case. Let's spend a few minutes. It's sort of a side thing, but our colleague Ryan Goodman did such a kind of elegant and meticulous treatment of the sort of very important material differences between what we knew about the showdown as it occurred in January of last year that prompted the resignation, and what's being said now. So you must have read Ryan's piece, yeah?
Of course,
you don't not read any Ryan pieces, so it's really true. I mean, there's certain things that I think he. Well, what jumped out at you from reading from Ryan's work here?
Well, so first, it's in Just Security, which is a legal blog that Ryan helps run at. Is affiliated with NYU School of Law, and just
where you teach,
yeah, exactly. So Ryan and I actually are co-teaching this year. So full disclosure, I'm a Ryan Goodman fan. So he's.
Have you met people who aren't in that club? I haven't, but go ahead.
Yes, that's true. People don't say that about you and me, or at least me.
It's true. No. In fact, I noticed on Twitter we're lumped together. You're better than me, but we're both complete apologists for DOJ, etc. And Ryan, why he is beloved not just by all the audience, but by his colleagues, he really generates interesting content and shares it so generously. So a
Yeah.
little plug for Ryan there. But anyway, yeah,
He's also a true academic in the best sense of the
yeah.
word, which is
Hmm.
that he is really dispassionate and he bases his opinions and where he comes out based on the facts. And it doesn't matter what he like his preconceived views or
Yeah,
really what
that's right.
he decide. I mean, it's really what you want academics to be.
As do you and I, but it's a longer.
It's not
Okay, but anyway, go ahead.
not about us. So there's
Yeah,
so many
enough
great
about us. Yeah,
there's enough great points, and there are many of
yeah,
them. I think one of them is he takes Mark to task for painting a picture in the resignation letter, the one that's leaked a few weeks after the public departure, and he takes task with the idea that there was a uniform consensus that this case should be brought, and that it is Bragg versus not just Pomerantz, but everyone on the team.
yeah.
And Ryan just goes through all of the ways that that's just simply not true.
It's indefensible.
Right.
Yeah,
Harry, pointed out to the outside advisors being split. Well, it turns out internally, there were a lot of maybe most, if not all of the people who were below Pomerantz and Carrie Dunn were against this. And some people had taken themselves off the case because they thought it was sort of being reverse engineered by Mark. And we gave one example of that. So I just think that is just not fair. And it clearly was creating a public perception that is not accurate. And we just talked about Ryan Goodman and how meticulous he is and so governed by the facts. And, Mark Pomerantz is not emulating that example in at least that illustration.
and it's a very important point. But let's go. Let's zero in on this because, well, going back to being on Deadline White House, where you live, and so you would know even better. Somehow this got confused this point with the question of the merits of the case because come on, everyone knows Trump committed crimes again and again and again, and why is Bragg such a wuss, etc. Can we zero in as prosecutors on the kinds of considerations, we weren't there, though Pomerantz takes us partly there, that a sensible, sober prosecutor would have been raising in December of 2020 to say, look, of course, he's a criminal generally, but here's some problems with trying to prove this case beyond a reasonable doubt. Can you illuminate the good faith concerns that senior people would have had about bringing the case?
Yeah, absolutely. And that actually, just saying something positive about Mark's book, I mean, he,
Yeah.
towards the end of his book, has a really, I think, excellent chapter about that tension, about
Yes.
what is the right standard here when you're going after somebody so prominent and an acquittal can have such consequences for the country, and how strong should the case be,
Right.
is applying the exact same standard to everyone.
And I'm sorry to interrupt because this will be two questions, but that really is it exactly. Again, I find this a pretty shades of gray situation overall, but I think basically Pomerantz, you take everything from him and Bragg, and you locate this in the exact fault line that DOJ and all prosecutors are on that has to do with downside, and it has to do with special considerations because he's the former president, the greater risk of even a hung jury, but also the righteousness. That's what I think Mark does come back to, and a lot of people, I'm among them, share that view. But it falls to individual prosecutors or even heads of offices like Bragg to have to own a debacle, and that's a real and serious consideration. So we're prosecutors in the room. How are you going to prove this, and what are their strong points? What's the nature of the hesitation that's expressed, do you think?
Well, I think in this situation, on there's sort of two buckets of potential crimes. One has to do with hush
Yeah.
money payments to Stormy Daniels. And I think everyone seems to be on the same page there that is a relatively strong case, but it's a relatively strong case as a misdemeanor under New York law, and there's significant legal hurdles to make it a felony.
In
There,
brief, you need another crime,
yes,
basically, that's in the process of, yeah.
and there is, even with a misdemeanor, there is a factual issue about you would have to show Trump's knowledge of a false filing, of a false business record. And there's nothing in the Pomerantz book that actually, to me, answered that question.
And one more thing on there, it's always about intent. He said it at the time, he didn't do it for, it would need to have been for campaign finance, chicanery. And he said he was trying to protect Melania's feelings. Now, nobody really believes that, but again, beyond a reasonable doubt, on intent evidence is always the sticking point.
Yeah,
Sorry,
and
go
the
ahead.
second part is the sort of large financial statement fraud. And there, I thought there was a bit of a disconnect in Mark's book, because he spends a lot of time saying you need a narrator, you need a cooperator. And he talks a lot about why Michael Cohen, even though Michael Cohen, pled to perjury, and also even after he pled, recanted some of his pleadings, which is really not a great fact.
Yeah.
I mean, I put on Sammy Gravano. I have put on
There
really,
you go, Sammy the Bull, right.
but it's very hard to put somebody on when they've committed a crime after they've said they're going to cooperate.
Right.
All of the arguments about incentives go away. But anyway, he says it's really important to have a narrator, and you need an insider, and I agree with that. I mean, in Enron, you need someone there. In the Manafort case, it really helped to have Rick Gates there. Not that he was necessary; we indicted the case without him. But having somebody sort of walk the jury through what they know happened, but they need to have someone say it. This is what it is, and then they look for the corroboration. But on the financial statement case, there is no insider. There is nobody who is cooperating who gives that, at least according to, at least as of a year ago, according to Mark's book. Maybe they have somebody, maybe they don't. I suspect they don't. And so that is a case where it's really just inferential. Now, you can make pretty good inferential cases depending on the documents that you have. But this is Donald Trump, like a lot of people, like mob bosses, like Jeff Skilling and Ken Lay at Enron, do not use email. There's a reason people don't use email. There's a reason Vincent Gigante said, nobody gets to ever use my name. He didn't want anyone to be talking about what they're doing.
That's every boys and girls. That's the bathrobe guy wandering around in the West Village. Great, colorful defendant. Sorry, go ahead.
And the boss of the Genovese family. So people take steps, but they can't be pinned down to what was happening at the time. So that makes a criminal case harder. And so I really, based on reading the book, I could understand an honest to God, good faith disagreement on whether there was enough, even if you agreed on the standard that it was being applied, but whether this really met that standard. I don't agree that this would be an easy call, and in a New York Minute, anyone else would be charged. This would be a serious conversation. Yeah. I ran the fraud section. I have dealt with very complicated white-collar cases, and when you don't have documents or an insider, the idea of going forward would be exceedingly fraught. I can't readily think of a case that we brought where we didn't have either of those. When we charged
Let me push back. Oh, I'm sorry, go ahead.
When we charged Ken Lay and Jeff Skilling, we didn't have emails, but we ended up with cooperators who could take us into the room, and corroborating them was key. Other times you get over that because of the person's own writings. But to have neither makes it a very difficult case.
Yeah, and this is what I meant up top, Andrew, when I was, patting us on the back. It really matters that you and I have seen a whole spectrum of cases, and you can see how this, people are making sort of judgments about how it fits in the whole. When it's just you. It really helps to have had a broad view. But I think what you're saying, obviously, there are documents here with radically different and false valuations, but what we don't have is documents, e.g., emails or people in the room as to guilty knowledge. Now, the closest thing, again, it's for listeners out there. You have people on cable channels who are saying, and it seems believable, that well, basically a person, Michael Cohen, Donald Trump, uh, controlled everything. He knew everything that was going on, and I think that's part of what Andrew means by inferential. You can infer that he did there. But I just want to say that when you're having this kind of crucible conversation among prosecutors, it's just very different from a friendly roundtable. You think about what a bruising cross-examination looks like in the hands of skilled defense attorneys and how much blood is on the floor after your star witness has testified and what it feels like for the case. That's very different. Now, there was one document, whatever you want to say, but I'll just add to the mix. There was this one document that I hadn't been aware of where he did Trump, the application for Deutsche Bank, and with that contained a lot of false statements. How would, if you're assessing the case, I assume you wouldn't think that a silver bullet. Why not? But also, please, what anything I prompted from before. Yeah.
Well, this is where if you're a trial lawyer, a lot of times you can hear Michael Cohen on a cable channel saying, "Well, he knew everything."
Yeah.
I don't think that's admissible. You actually need to know. That's an opinion. It is like, what's that based on? I mean, you actually need to have. How do you of everything? Okay, so
No sense fighting this out, but let's just assume for now that much might be admissible, but just very. It seems to me there are ways to get that in, but we don't have to fight the evidence question. But even so, here comes the bruising cross examination.
yeah, absolutely. Uh, I think what you would get in with Michael is like, he was careful. You'd get the underlying facts from which you could then make an argument that he was a micromanager. And then you get to argue to the jury. But the conclusion that he knew everything is, I think, something not admissible. But anyway, we don't have to. We should be so lucky that we get to the point where we are arguing that for real.
Yeah, right. We should have such problems, right?
So when you have a piece of evidence that a defendant signed something, that obviously is good for the government, but you really need to know the circumstances under which they signed it. First, how long is the document? What were they told about the document? Did they read the document? But there's also this legal issue under New York law, because it's not a terribly attractive case, because federally you wouldn't have to show that there was actual causation and reliance by the victim bank. But under New York law, and I'm no expert on it, and this is, one of the tensions in the book and between Pomerantz and Bragg is sort of that Pomerantz was never a state New York lawyer, and so doesn't know the law on that, is that there is this need to show causation and reliance, and that there are ways to try and charge around that. But it was really unclear that Deutsche Bank actually cared about this stuff, and the loans were all paid back. So there was both a factual issue about what he knew and what he understood when he signed something. And then there's a legal issue about, does it even matter, because the bank wasn't harmed and they might not even care. So again, that's, by the way, it's certainly a good fact to have Trump signing something, in the same way that in the Trump organization trial, and the one that Weisselberg pled guilty to and ultimately testified in, it was a good fact that you had Trump signing off on some of the sort of reimbursement payments because it's not enough, but it suggests knowledge. But Pomerantz, to his credit, said we didn't charge Donald Trump personally there because we didn't have an insider. We didn't have somebody walking us through that. And so that argument, which I thought was compelling and convincing as to why Donald Trump wasn't charged in the Trump org trial that the Manhattan DA's office brought and convicted and won. But I think that applies equally to the financial statement case, where you are going to, at very least, cases where you're going to have that same question about you have neither emails nor a witness. Now, it's very hard to say this is apples to apples because a lot of this is very factually dependent on whether there's enough proof or not. And I have to say on that, leaving aside the whole brouhaha of who got jammed up and what was said and who said what to whom and was there bad faith and all of the things that are, the muck that swelled, at the bottom line is you could imagine good faith on all sides, and this is an honest disagreement about whether there's enough. I don't think that's worthy of disparagement in the press, of any one side. But, Harry, you and I, I'm sure, have been in situations where there's been a debate about whether to bring a case or not. And there's people who disagree. And you're not thinking that the person on the other side is weak or lily-livered or dishonest. You're just thinking this is somebody with an honest assessment of the facts who's viewing it differently.
I'm very glad to hear it, in fact, as an ultimate decision maker. But look, there's no doubt he is politic. He, with a few notable exceptions, doesn't trash Bragg. Pretty tough on the office. But there's no getting around the score settling aspect of this. I just had a quick follow up point and then a question. So the follow up point is, so on something like the quirk of New York law that you might lose on materiality, you have to be aware that that's the same as an acquittal. It doesn't matter what the reason is. You go after it, and Trump wins this bizarre legal motion, or there's either a dismissal or a hung jury or whatever. That's as bad. That's just the headline is just you shot at the king and you didn't kill. Let's see, in the time we have left, let's talk a little bit about where we are now, because Pomerantz canvasses a wide range of theories. Another, by the way, implicit rebuttal of the notion it was such a dead bang winner. If that were true, you'd figure out the main theory and go with it. But they obviously were considering many different things, different crimes. Now Bragg has reassembled.
Wait,
Go ahead.
Up until mid-December 2021, they were still futzing around with what theory might work. I mean, this is like 2 weeks before the new DA comes in. So
exactly,
you could hardly say, oh, this was all baked.
Yeah, that's right. I mean, including the forcocked one about the money laundering, victim blackmail, etc. Okay, but now let's flash forward to, I don't think we've had any credible reporting. That doesn't mean it doesn't exist, of really important new evidence developed by Bragg. And in fact, there are also indications that his focus is on what's the people in the office called the zombie case, the one that wouldn't die, and that you've referred to properly as the kind of money laundering or campaign crimes, whatever, involving Stormy Daniels. It seems to me that Bragg, after all that's happened, when he reconvenes a grand jury, it's not to just kind of, peruse possibilities. He wants to go because it's going to look, if he has a grand jury and then he again says, never mind, he'll really look weenie-ish might be the word, but on the other hand, we don't seem to know what now has come to his attention that makes it look like such a strong case. So, do you have a sense or surmise of the specific case they're building and whether it's different from one of the several ones that Pomerantz and Dunn and company were constructing back when Bragg first came in?
I don't. I have some thoughts. But I agree with you that it's very opaque,
Yeah.
almost frankly as it should be, which is that since Mark left, there's really been no or very little leaking in the sense that you
Yeah.
don't see any sort of sense of what's going on. A couple of thoughts on that, though. One, they did have a trial in the fall, and and if you remember, Weisselberg and the Trump organization were doing
Yeah.
everything they could to delay that case. And to keep the trial date, I could see the office trying to keep as much as possible out of the press, to not give any fodder for change of venue, motions about delay. I don't know that happened. I'm just thinking about what I would be thinking about if I had an upcoming trial and I really wanted it to stick. If you remember, there was a lot of
Yeah.
pushing where they wanted the trial to happen
Good point.
after the midterms.
Yes.
And the trial didn't happen after the midterms. So that's sort of one point. The second is that there are signs that, with respect to Weisselberg, that the strategy was, okay, he gets charged. We work out this unusual agreement that's very bespoke. He testifies, he goes to jail, and he is currently in Rikers. I mean, nobody should be in Rikers. He's a
Right.
75-year-old
Just a
man.
hellhole, right? Rikers? Oh my God.
There's
Yeah.
tons of litigation over it and the conditions there. And,
It's frightening to walk through as a civilian, honestly.
so he is there now. There have been reports in the New York Times of discussions between Weisselberg's defense lawyers and the prosecution about potential new charges. If you remember, when Weisselberg pled guilty, and I wrote about this for Just Security, a really unusual feature was that there was no coverage given to Weisselberg for any crime other than what he pled to. Usually, when people plead guilty, the defense lawyer wants a piece. They want to know that the person's not going to get charged again. They want to know, okay, if he pleads to this, is he done? And prosecutors tend to work out some kind of language that gives them some protection, depending on the circumstances. Here, what was unusual is there was no coverage for anything. And then when Letitia James, the New York Attorney General, brought her case, buried at the very back of the complaint, it's like, it's like paragraph 600 and something, is
Right.
direct allegations about Alan Weisselberg committing insurance fraud. That is,
Yeah.
and so when I saw that,
But that's in the Times story.
yeah,
It seems totally solid. Yeah.
so, and it seemed very objective, and there seemed like you could
Yep.
go to the victim insurance company and get the information. And it was all about Weisselberg saying that our financials at the Trump organization are audited when they're not. So that seemed really solid. And so one of the things you could be doing if you're the DA's office is saying, well, there's nothing that focuses the mind like being in Rikers Island and facing new charges, and hoping that puts as much pressure as they can on him. And maybe he flips and maybe he doesn't, but they then at least done their job, which is to take all appropriate steps to hold him to account criminally and hope that he changes his mind about cooperating.
Yeah. So I agree with that. It's just I think there's, as you say, it's opaque and there's no clean theory. It's just, to me, given what the consequences politically, and he's a DA, he thinks about it, for Bragg, of convening this grand jury and then tiptoeing back, suggests strongly that you'd have done this first. And he didn't. So is he really hoping and rolling the dice? Andrew Weissmann, I started this podcast many moons ago because I felt that the sound bites on TV that former prosecutors who were, supposedly had specialized knowledge, just didn't do near justice to the real conversations I'd experienced with colleagues as a prosecutor. And man, This totally brings it home. It's a pleasure really to talk to you, and it's really the thing that that just can't be captured on cable. Thank you so much for being here to tease through a really interesting but tricky situation that is dominating the news. I'd say in a more superficial way this week. So nice to share this time with you and try to muse about it or surmise about it together.
It's great to be nerds having this conversation. I really
Yeah.
appreciate it. And it's
Oh, you're not a nerd. Come on, Room Raider knows better. I, on the other hand. All right, and with that, thanks, and hope to see you, Andrew, soon, and everyone else as well. Thanks a bunch.
Take care.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.